Okay, the reason for doing this tonight is, oh, hey Heather, what's happening? David, Malika, what are you guys up to? Just wanted to come on here, answer some questions, go over a more advanced level version of stuff we talk about on Kirk's Law Corner, specifically to kind of go over more of the specific stuff when it comes to what it is I do, how I created it, where it all came from, and the whole kind of give you the rundown of sort of the start to finish. So, and this way, I think it'll help you guys better understand what I did and why. So let me go in here and I'll go ahead and start the live stream. Obviously, I won't be able to see comments while I do this, so I'll have to check those later. Now, knowing and understanding what an emolument is, okay, and I started to see this word reappearing all over the place. And it actually started when I started looking through my oath of office. And I've been through this with you guys, but I'll cover it again just because I know my little girl's watching this and she's going to want to kind of be able to clarify this a little bit. So here's the word in my oath of office right there. Okay. So not doing what I do, study was the first best course of action for a multitude of reasons. As a fiduciary, there's the license. You kind of need to know and understand the tools that are in your toolbox. I joke about using a screwdriver as a hammer, and so to speak. So when we look at the definition of the word in its raw form, it's kind of vague, right? Any advantage, profit, or gain is received as a result of one's employment or holding of office. Well, I knew what I wanted to do with loss prevention because I knew what it always did, at least in the private sector. And it wasn't until after I had done this parliamentary inquiry, which is this bad rascal right here, where, and I've showed the video on Kirk's Law Corner, where Dianne Feinstein asked Bill Barr about the emoluments clause. And his answer was, well, emoluments are a stipend attached to some office. So now we go back to the definition. I was looking at it as the advantage, right? And he went more towards the profit or gain when you talk about a stipend. He didn't actually call it a profit or gain. A stipend is just a different descriptive adjective of either one of these two things. So, but it was more his body language, which told me that chances are I was probably dead nuts on with my original assessment as the advantage being the first and foremost of importance when it comes to your actually interpreting your oath of office. Because like many other people, I took my oath of office and I put it in a frame, put it on the wall. That's generally what every time you go somewhere, that's where you see them. Business licenses and relative other licenses, it's the same thing, right? So knowing and understanding that, well, I needed to break this bad rascal down, okay? So each one of these components, and I went through how I typically, go through various litmus tests to test a theory, the scientific method, emoluments equals the quantity of advantage plus gain divided by profit. And I broke it down three ways on the board. And no matter how I went through that, I still don't know if that's 100% inaccurate yet. because I haven't gotten that far in the research. So that litmus test is still right here in my mind, because it is part of my scientific method, and it is sort of kind of mentioned in the book when you go through the actual well, aside from the principles and practices, the general motion practice, what is debatable, that's part 2 in the book. Next section in the book, part 3, rules governing motions and proposals for action. So, for example, if you want to discuss things like a litmus test, what are the rules, around that? What's the difference between a privileged motion? Now that goes to the advantage, right? Anything privileged would be, there are multiple definitions throughout, that I've discovered throughout this. When I think of privileged, I think of privileged communication as a fiduciary. In other words, I have a client who wants to tell me something in confidence and know that that's not going to leave the bounds of the office. To me, that's what privileged means, privileged communication, right? Well, and as it turns out in the book, it does go to the advantage part of the emolument, as shown here. So, and that's why I said, as I studied the book and I studied the not just the differences, but the so many similarities of what we used to do in private meeting rooms. And I even gave an example of one, of a problem that we had, and how we used a quorum process, right? Where we called a certain segment of our company into the quorum to say, we got this problem and you guys are the ones in the field, and what do you need from me to help us solve this problem, right? So this again is an example of trying to figure out how to take what I did, knowing that it mirrors this book, and put it in their language so they can understand it. Okay, so again, it's all in the art of the communication. You get into this whole thing about the, part 8, where they go into relations with the other houses, and of course, relations with the executive and other houses. So, in other words, if we're going to invite an executive officer into the quorum, there's actually a process for that, which, of course, to me, it was just somebody picked up the phone and called the CEO and said, yo, dude, you might want to come over here and check this out. But apparently there's a whole nother process that goes with that in this book, which, of course, I was unaware of until I studied the book. So then, of course, we go into meetings, sessions of state and legislatures and that types of things. So that's where you really that's part 9, where you really start getting into the nuts and bolts. And it's not a very long section. It's actually only 1, 2, 3, 4, like 5 pages. But there's an actual process governing sessions of state legislatures. So knowing that there is such a thing, we have to follow that, right? That's accepting proper decorum. And you see that referenced in the House and the Senate rules. So again, knowing that, for lack of a better expression, though I was experienced, obviously, in loss prevention, part of that process is, what are the rules of the game, right? We're going to, I compare this to Monopoly. Well, house rules apply. That's one of my favorite jokes is, yeah, I'm going to put houses in hotels and we don't have to own all the properties. I think pretty much everybody plays Monopoly that way. But so anyway, let's go into the focusing on the advantage. Okay. Because the focusing on the advantage is your standing in law. Now, whenever you have an advantage over somebody else, you need to be very, very careful with that, because there are repercussions for that. I mean, there's good and bad to everything. So I said, okay, in order for me to introduce loss prevention, okay, from the corporate world, knowing what Title 42 was designed to do was to enforce. Basically, I said, look, we need to enforce equal protections under the law, because at that time enforcement was the issue, or lack thereof. And this was the second document. I think this was the one where this was my where I registered my logo. So now, of course, this one is, I've been in business 2 years formally, and you can verify that. Just take this tracking number, put it into this website, and this is posted out there for you guys. So this takes you right to the website, and it says that E-Clause is active. Okay. And it is a lawful business created in the state of Florida, as it says here. So now I've established from a combination of things. Now I'm a corporation. Okay. There's the corporate charter. There's where I registered my logo, sort of my name tag, if you will. And look, I'm willing to play by the rules. That's what this says, right? Okay, it says basically this is me acknowledging I've read the book, I play by the rules, and because of the Executive Order 13781, I said I'm going to pull this thing out of mothballs, and I'm going to show you what a professional, actual fiduciary relationship agency practice looks like, since we're talking about interstate commerce and agency contracts. Okay. Any transfer of real property has to go through a very specific set of criteria. It's not just a haphazard thing like you sell a car. You go sign the back of the title, you go over there into the DMV, and you process the paperwork through there. This is a little bit more complex than that. So anyway, this is registered with the real estate business agency, which is part of the Department of State, which is through the Ohio Congress. So I said, okay. In the beginning, I said, here's how I'm going. This is my standing. This is where I'm going to be when we're talking about agency practice. So just so you kind of know who you're talking to, say, go in, identify yourself, kind of raise your hand, be polite. So this is what I'm saying. This is who I am. And when it comes to addressing the executive, well, that's the governor at state level. So here's my oath of office that grants me standing to do that. And of course, I've shown that there is such a thing as a jurat form, and that goes along with your paperwork when you file it and you register your corporation to do whatever it does in practice and in court or any kind of judicial format or setting where you're going to be making law, making policy, or making some form of a group decision. You have to have all of these things on file. You know what I forgot in here was my errors and emissions insurance crap. Oh, it's up on the wall behind me. Anyway, so let's go into when we pulled the agency decided they were going to pull their crap, and they didn't like what I was doing. So they threw me in jail, right? Like they've done to so many other people. And I said, well, no, under res excipiendo fit actor and Florida Constitutional Article 1, Section 11. No, actually sections 9 and 11. No. So in the meantime, this was not fully processed yet. Okay. So all of this crap was going on at the state level while we were still litigating this in Congress. This also showed Congress that, look, when you stand up to these guys, they are going to retaliate, just so you know, right? So when I decided to go ahead and say, okay, you want to pick a fight? Here's what a fight looks like, right? I'm not backing down. And I made that very, very, very clear. You're dealing with somebody who's probably forgotten more about practice than most of these idiots will ever know. So not only do I know the difference between the theory and the practice, I've spent my entire life doing the same thing that Congress is supposed to be doing but hasn't been doing. So that's why I said there's a whole lot of learning curve here. I talk about the learning curve all the time. And because training was always part of my job, this is what training looks like, right? Now, the entire document is 1,564 pages. That's everything that goes with the supporting petition, which is the cover page. So, for example, where was I think it was here. Yeah, in the parliamentary inquiry, we're talking about treatise of malicious prosecutions and false arrest and imprisonments. Even though that hadn't happened yet, that's exactly what was happening across the country with these unlawful emoluments as unauthorized practices of law, right? So in the meantime, this mandate gets issued and says, yeah, we want to know more about this. We know you're following due process of law. We know what the fourth and fifth pillar elements are doing. But as far as actual law judges, okay, now this is where it starts to get really hairy. Administrative law is fourth pillar and fifth pillar practice. Okay, that's where it's built in law. So by the time you're actually working your way backwards. You're working your way from the fifth pillar down to the first pillar. That's why I said they're reverse practicing this stuff. This is what I've been trying to explain. So knowing that they're starting you in this administrative fifth pillar thing, knowing you have to go through 5, 4, 3, 2, 1, knowing, of course, that I'm reporting to Congress, the first level, the second level, which is the executive, and then, of course, now with the I had actually originally filed a habeas, I think, at one point in time, which, of course, we knew they would deny, which they do all the time. So that was one of the reasons why I pulled this quote from the Treatise of False Arrest and Imprisonments, right? I want to get your attention. And one of the things I wanted to get their attention is we are talking about the common law. Why? Because we're talking about the republic, the three pillars of our law. And there's a maxim of law that states we should follow our own law rather than foreign law. So that's also in the document. And just for flavor, right, I pulled a couple of most applicable declared acts of tyranny from the Declaration of Independence, because that's primarily what I practice, right? Talk about what body of law you follow. I follow the Declaration of Independence when it comes to this. Why? Because we're calibrating the scale back to 0. And 0 is our nation's birthday. So when these bar members, knowing that they hate the Declaration, they refer to it as a, what was it, an act of treason at the time or whatever, and, they try to dismiss it. Well, the problem with that is anybody who sits in government that accepts the emoluments of Independence Day accepts the Declaration of Law, which is one of the reasons why multiple case precedents, including Troxel, reference the Declaration of Independence. So it is law, whether bar members like it or not. And again, this is what it takes to ram it down their throat the same way they try to ram it down ours. That's why I just said, hey, I know how that works, right? I've been watching you guys pull this crap for decades. I just wasn't totally aware that it was my job that was going to fix this problem. So now that I've identified where I'm standing in law, okay, and I've already now included this judicial mandate, which I didn't expect. I didn't expect them to grant me standing after you've been dismissed and been told you're a piece of shit, don't ever come back so many times. You just say, right? You expect their arrogance. It is what it is, and everybody knows it. So When this actually came down through and it was issued, as it was issued, basically stating me versus the Department of Revenue, knowing that the Department of Revenue had it back, was saying it was the other way. It's like, okay, I think I know what they're trying to do. They're trying to reverse the reverse of the reverse, right? Kind of like you ever play Uno with just two people, reverse, draw two, wild, draw four, and you just you can pound your opponent with reverse and skip and draw twos. And I think pretty much everybody's ever played Uno with two people has done that. So this is pretty much what we're doing, because remember, there's only two parties here. Me and this Department of Revenue actor, right? And because it was the Department of Revenue actor that actually committed these unauthorized practices of law, because they're not constitutional and everybody knows it, the bodies of law that redress that, there's two of them. Because when we talk about unjust conviction law, which is right above, there's the treatise on malicious prosecutions, now they don't usually use these two together. They pick one or the other. Treatise of false arrest and imprisonments. This is the most common. They shy away from the malicious prosecution one because they do not, how they are with, you can't go after the legal profession. We're gods and blah, 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 all that arrogant bullshit that we laugh at. So knowing that we're talking the common law, I'm saying, yeah, I know what your bar word salad says. I've read it more times than I care to even tell you that I've read it. So I care about your bar crap about as much as you care about my Mason's manual. Well, because Mason's manual is Article 1, that's where the oversight happens. So if you screw up, this is where we're going, is, knowing, of course, Ohio and Florida, those are the state level. And we've got 5 pillars of law at the state level. So the states are no longer in Republican in character or form. We know this. Okay. So where do you take that grievance to? You take that grievance to DC. And along the way, through the deciphering of the, I think it was, what was it here? No, it was here. No, maybe it was here. No. I had it in here somewhere. Crap. Oh, I remember where I put it. Okay, there it is. In the meantime, I've decoded this Title IV scam. And they said, well, where's your bitch? I said, my bitch is this Title IV-D thing. Because according to this actor at the Florida Department of Revenue, this idiot here, this guy, he says he's from this thing. Is this true? Right? This is me walking in there and saying, yo, dude, what do you think you're doing? Right? Now, of course, knowing that due process of law is what it is, when I filed into the Florida Supreme Court, okay, there's the filing date. Okay, so any questions about that, those are now answered. I brought it in under this appeal number and said, well, the appellate court says, yes, it is, apparently I'm correct, it is me versus them, not them versus me. But based on the arguments, the other side didn't even really make an argument other than their typical word salad, which makes absolutely no sense. When you go through and you read the state level appellate brief, and the way the judge wrote the mandate, according to the mandate says, well, if it's me versus them, that means they're affirming my argument. Is that or is that not true? So, of course, I go down through here, and I'm going to post this up here so you guys can read it. This is the actual Supreme Court document. I don't know if they don't file stamp every page. The way these guys, the way they do it in federal court, see how they file stamp here across the top? They do it across the top of every page at the federal level, but they don't do that at state level. So anyway, be that as it may, by the time I got into the history of this, let me get down to that. Oh, past it. Knowing that me being me, I called them out on it, right? So do you want to talk about law? All right, let's talk about law. Let's talk about the pillars of law. Our republic only has 3, right? Your representative democracy bar association crap has 4, right? And it is this 5th pillar element that is, both of these are repugnant. Now, here's where the problem lies, right? 4th pillar, they know they're repugnant, right? We threw them out of here with the original 13th Amendment. Then this 5th pillar shows up and completes the pyramid, like they're sitting at the top of the pyramid. Like I've shown the architecture, it was on the board behind me. So it's like, okay, you guys, I know who you think you are, and I know how smart you think you are, but you're full of it, right? So that's why I said, you want to play pillars of law? I said, I'll be the 6th pillar in the Star of David. Now, I know that's supposed to be an octagon, not a hexagon. Sorry. Anyway, this is a, they pretty much, they got the point, right? This is me telling them that their stuff is word salad. So let's go down towards the end here. Here's the decision, right? Court says, well, this court lacks jurisdiction, right, to review an unelaborated decision from a district court of appeal that is issued without opinion. Well, again, that's why I said, all they said was, res excipiendo fit actor, me versus them, was affirmed. But where's the opinion that went with it? They never wrote one, right? Because in order for them to write one, the way I'd constructed the brief, they would have had to admit that the 4th pillar of law is repugnant to our form of government. And oh, by the way, so is the 5th. And because these actors are sitting in a position of emolument in this legal profession, right? They're purporting themselves as these bar members, right? This is the infiltration, this deep state we talk about. Well, I just went in here and proved to them that they're not as smart as they thought they were. And the only way for the court to say it was, hey, okay, yeah, okay, that's it. We're not going to admit we're busted, but here's what we will do for you. No motion for rehearing or reinstatement will be entertained by the court. In other words, that's it, you're done. What this does, this is key, is because this establishes a bar to prosecution. Now, what is a bar to prosecution? A bar to prosecution means that anytime anybody ever shows up and wants to claim they are with it, claim that they're with these guys, right? Whoops. Didn't mean to do that. They're claiming they're with these guys. No prosecution. Okay. So here's the good part about that. Now, as I take this and I process it through the remonstrance and through the various other mechanisms that, I've created over the course of my practice, part of the remonstrance is to go to the state level and say, well, according to the Florida Supreme Court, this is so repugnant, they're not even willing to entertain another motion for rehearing or reinstatement, right? So if this is repugnant, this whole damn thing must be repugnant. Void for any effect from its inception. So, that said, many of you who have had issues with non-enforcement of either A, B, or C is one thing, but what's Title 4E? How many of you out there having issues with CPS? What's that? Oh, another fifth pillar entity? Remember that Sharia law that we talk about? You need proof of that? Well, here's the proof of that. How many pillars you see? I see 1, 2, 3, 4, 5. There they are. Totally properly identified as, not entitlements, which is what they claim they are. Those are emoluments according to the Constitution. So if we're going to make a constitutional argument, that goes to where? That goes to the Article 1 branch into the legislature. That's the reason that getting the bar to prosecution was super critical. So now when one of my kids calls me and says, "Hey, Dad, I need $100 or I need a $20 bill," I don't have to send them a $100 bill so to make sure they'll get $20. Right? Took me 10 years to solve that problem. And of course, I know Amber doesn't sorry, honey. I know my daughter doesn't understand that. But one of the reasons why I wanted to do this tonight, even though it's so late, is because she's going to watch this later. And I want her to know that this is the crap that not only I've been fighting, everybody that I work with is fighting this exact same problem. So as far as who brought, where the hell was that? There was the judicial mandate. Well, I've showed this before. I'm going to show it again. Who brought in your mother? That would be this Department of Revenue, because they're claiming that they're acting on behalf of, or they have this fiduciary duty to represent her. So the thing that I had to do to protect her and you was to sever this on behalf of and prove that it is unlawful. And the only way to do that was to handle it how I did. So, again, this process, me fighting these same silly sons of bitches here, goes back to your oldest brother. So if you disbelieve that, just ask him. He'll tell you. And moving forward, what this is going to do for you going down as far as further down the road is concerned, well, we can do a whole lot with this. We can pick any project we want and go right into research and development. It doesn't have to be just law. That's the beautiful thing about corporations. They are expansive or reductive in any way, at any shape, in any form, or at any time. So by bringing you kids in as corporate officers, you are now protected by the corporate veil, right? This is one of the reasons why I didn't bring it up here, but I know you kids got a copy of it where that crap they were trying to pull against your mom up there, how it was all of a sudden conveniently transferred, and from there it just poof, disappeared, gone. Because they knew if I have to come up there, this was already on the table in Ohio, and this was already on the table in Washington, and they knew damn well what I was coming after. I've already had it done. So getting the bar to prosecution, meaning they can't prosecute the people for this crap. Okay. So not only does that free me up, but that frees up about, pretty much everybody who was ever affected by this Title IV emoluments scam. the sham, the shit show, shit made up, fake jurisdiction, right? Emoluments of statutable plunder, as I put it on the cover page, referenced in Annals of America, Volume 2. So, I hope that answers your question and how it works and why I had to answer this question, to define this one word, why I had to take every tool I had in my toolbox and build something that was never before done. Because I knew darn well that there was no way in hell that I was going to pick up, because I picked up the phone and I called how many tens of thousands of dollars in attorneys already. And they go in there and you say, make the appointment and say, this is what's going on. This is the argument you got to make. And they go, well, I can't make those arguments. But you still want me to pay you, but you can't make these arguments. Well, what good are you? That would be a bad business decision, right? Oh, and as a businessman who is pretty well versed in business, made a lot of money in business, I know a good business decision and a bad business decision when I see one. So this is the reason why I just said, you know what, I'm going to take this bull by the horns. I'm going to go up there. I'm going to ram it up their ass, whether they like it or not. And the fact that it worked, hey, it is what it is, right? So I wonder if I could go ahead and now I have to change. And I don't want to change the original document. I'll change that because the case number is S. Hang on a minute. Oh, I can show you that right here. It's on the order. Duh. There's the case number. SC 19408. So anybody who wants to know, tell you what, I'll zoom in on that for those of you who are on your phones. Oops. There's a case number. There's the lower tribunals. I didn't know I was in the military. Right? This was supposed to be a civil matter, civil in nature. Civil in nature does not use a court forum. Civil in nature uses a quorum or jury style format, correct? So that's the reason that I was able to pull this off. And again, I'm going to go ahead and end the live feed there, at least end the recording, so I can stick this out there on YouTube.